The question is that the bill be now read a second time. Mr. Patrick Tay.
In support of this bill. This bill seeks to facilitate the restructuring of distressed companies and benefit local businesses experiencing financial difficulties. Indeed, companies are under pressure from rising costs, a shrinking workforce, and rapid disruption in an increasingly protectionist global environment. Many of our businesses are also restructuring their operations in a bid to stay ahead of the game. As restructuring intensifies, it is inevitable that some businesses in Singapore may end up distressed or in financial difficulties. While this bill seeks to strengthen the regimes in place to facilitate the rehabilitation of distressed companies, we must not forget to ensure that the interests of workers are taken care of as well. Without a doubt, workers are the lifeblood of the company. In times of difficulty, the company stands little chance of rehabilitation without its workers. Yet, workers often have little bargaining power vis-à-vis the company and stand to lose the most when the company is unable to pay their wages. Wages generally form a sizable portion of workers' wealth and means to sustain their dependents. When the employer defaults, workers are left with limited options to fall back on. Unlike other creditors that the business deals with, majority of workers would not have factored in the risk of entering into an employment relationship by looking at the financial health of the employer before they accept employment or minimize their exposure by taking a security. Workers would also not have negotiated into the price of their labor any compensation for the risk of non-payment. Thus, the worker is placed in a position of self-insurance, but without adequate power or compensation to absorb the loss of unpaid wages when the employer becomes unable to pay them. I've come across various cases where workers continue to work without pay while the company is in judicial management, in the desperate hope that the company will turn around and they can keep their employment with the company. For example, in February 2015, Vela Diagnostics came under judicial management in Singapore. Staff were informed that they could not be paid until new funding from investors was secured. The Ministry of Manpower, MOM for short, had stated that they were unable to assist employees for a firm under judicial management, as the Assistant Commissioner of Labour at MOM was not able to inquire into salary claims of employees covered under the Employment Act while the statutory moratorium was in force, except with the consent of the judicial manager or with leave from the High Court. One former employee owed about $13,000 quit in April 2015 to start a new job because he could not afford to keep waiting for his salary to come in. Others struggled with their financial commitments while staying with the company in hope that investors could be secured. Vela Diagnostics was eventually brought out of judicial management in September 2015 and thereafter settled all salary claims. By this time, the workers who had stayed on with the company would have worked for almost 6 months without pay. Unfortunately, not all workers in such situations get paid their outstanding salaries or at all. From 1996 to 2000 and 2001 to 2010, there were only 52 successful judicial management cases where all the debts were paid, out of 194 cases in total. That's something like 26.8%. And these were reviewed by the Insolvency Law Review Committee in 2013. In unsuccessful cases, workers would be left with little or no recourse for outstanding wages, except to await distribution of assets upon the winding up of the company in accordance with the priorities of debts in insolvency. Depending on the assets available for distribution, they may receive a few cents for each dollar owed, or nothing at all. With the introduction of rescue financing in 2017, the company may apply to court for an order that debt arising from any rescue financing obtained or to be obtained by the company to have priority over some or all of the preferential debts or to be secured by a security interest, pushing unpaid wages further down the priority of debts. In the case of Re-Atelian Group Limited, citation 2017 SG8C 283, the High Court rejected the company's application for super priority for rescue financing, finding that the company had failed to show that it had expended reasonable efforts to secure other types of financing. The judge also added that the grant of super priority should not be ordinarily resorted to get ahead of the queue for assets. It remains to be seen how the case law on super priority rescue financing will be further developed. While rescue financing can certainly give the distressed company a timely boost towards rehabilitation, I urge companies and rescue creditors to give considerable thought to the interests of worker creditors when mounting this application. In conducting their review of the insolvency regime in Singapore, the Insolvency Law Review Committee received feedback that in many cases where the official receiver was appointed as liquidator, typically of a company with no or little assets, the official receiver received almost no remuneration for the fees incurred in conducting the liquidation, and the cost of such liquidations were borne by public funds. The committee also found that a sizable number of companies ruled out by the court had insufficient than $1,000 administered by the official receiver stood at 320, constituting 42% of the 768 live cases administered that year. Under Section 328, subsection 1A of the Companies Act, the fees of the liquidator enjoy priority over all other preferential creditors, but share that priority with two other categories of debts within the same class ranking pari passu, i.e., the tax cost of the applicant for the winding up order and the cost of an audit carried out pursuant to Section 317 of the Companies Act. This is followed by wages and salary found that there were already insufficient funds to pay the official receiver at the top of the list of preferential debts under Section 328, subsection 1 of the Companies Act. The implication would be that workers who have not been paid their wages have even smaller chance at recovering any monies owed to them. I would like to ask the Minister if there are any statistics available on the incidence of claims for unpaid wages in insolvent companies and the amount of wages claimed by workers. In the winding up of companies where workers have claims for unpaid wages, what are the rates of recovery of unpaid wages by workers? In cases where workers have received some payment toward their unpaid wages, how long 203 subsection 1D, subsection 1E and subsection 1H? We must ensure that there are avenues available for workers to seek help when they are claiming for unpaid wages when the company is under judicial management or insolvent. I have four possible interventions and suggestions. First, currently workers with claims for unpaid wages can make a claim at the Employment Claims Tribunal by first submitting a mediation request at the Tripartite Alliance for Disputes Management. For workers claiming for unpaid wages against companies under judicial management or insolvent companies, TADM should share with these workers information about the implication of judicial management and insolvency on their claim for unpaid wages against the company and connect them to employment facilitation support and resources. Second, the short-term relief fund targeted at the bottom 20th percentile of the workforce funded by the Ministry of Manpower and operated by TADM for workers who have successfully made ECT claims against their company but failed to recover payment can also be expanded to assist all worker groups, including professionals, managers, and executives, who have not been paid wages by insolvent companies, and the amount of help increased to commensurate with the salaries of those affected. Third, the Ministry of Manpower can also advance money to pay part of the workers' unpaid wages and stand in place of the workers as a preferred creditor, of the same level of priority the workers would have had for a claim of unpaid wages, to recover the advance monies upon distribution of the insolvent company's assets. This will reduce the waiting time for workers to be paid and eliminate the hassle and stress of having to take additional administrative steps within the insolvency framework to recover their unpaid wages. Finally, there should also be exceptions to the statutory moratorium. Ministry of Manpower could be allowed to investigate and take action against unlawful labour practices under the Employment Act without having to seek the consent of the judicial manager or obtain leave of court. Unions should also be allowed to refer cases to the Industrial Arbitration Court for arbitration and not having to resort to industrial action. To conclude, much as we now have consolidated and promulgated a mammoth and laudable piece of insolvency legislation which I support, I submit that a worker's basic rights to his day's wage should not be diluted nor denigrated. Workers should not be bearing the manpower costs of rehabilitation efforts of the company. A better insolvency regime is one that facilitates the rehabilitation of distressed companies while providing sufficient safeguards for workers. In short, I hope this bill will not just be an omnibus bill, but also omnipotent to ensure both businesses and workers survive. Thank you.